Hi guys, Tool Wrangler here, coming to you live from sunny Canmore, Alberta. You can see the famous Three Sisters mountains in the background behind me here. Just thought I'd do a live out in the open in the wilderness, so you didn't have to look at the boxes in my office. Anyway, today we're going to cover a topic that's a little bit confusing. There's a lot of information to cover. I'll try to cut through the chaff. It's basically about patents and patenting. Should you patent? What are the different types of patents? What's the process? Some of the costs involved, roughly. I mean, I'm just full disclosure, disclaimer here. I'm not a patent lawyer or attorney in any way. This is experiences that I've gained through my own process. So just passing on some knowledge here for your benefit, hopefully. Um, I guess the first thing that we could cover is the different types of patents. The first one is called a utility patent. That's the one you're probably most familiar with. Utility patent is effectively a patent that protects a function of something. So it's less about the shape and the size and the color and the texture and the material, and more about what it does. What problem does it solve? How does it solve it? How is it made? You know, it's about the utility or the function, which is why it's called a utility patent. The other main type of patent would be called a design patent, and that gets more into the shape, style, size, material, function, that kind of thing. It carries a little bit less weight. You've probably heard of the claims if you alter a patent by 10% or 15% that you can get around it. That more pertains to a design patent. So while both have their place, the utility patent is definitely more broad. It's also harder to get, more expensive, and takes significantly longer. So one of the things that the American patent, USPTO, so the United States Patent and Trademark Office did about, let's call it 8 years ago now, was called the America Invents Act. And they recognized that the patent process was very long, very expensive, and excluded a lot of people from trying to protect their ideas. By the time a patent was granted, which actually afforded protection, chances are the idea was either knocked off or created already, or the market was dead. Typically, when something comes to market, it's only got a finite lifespan, and often the patent process is so long that it exceeds that lifespan. So by the time the patent gets granted, you're not even worried about protecting it anymore. So what the American Invents Act did was introduced a new method of applying for a utility patent, specifically through a non-provisional patent. Sorry, a provisional patent. A full utility patent is called a non-provisional patent. And so they created this new one called a provisional patent. And it doesn't give you any rights. You don't own the idea when you get a provisional patent, but it does act as a placeholder and secures a date for when you registered your idea. Let me explain that a little bit more. So basically, when you file a provisional patent application, which is also called a PPA, uh, it it basically says on this day, I am hereby claiming that this is my idea going forward, and now you have a 12-month window to act on that. What I mean is you have 12 months in order to file a full utility patent application or a non-provisional application. Or alternatively, you could file what's called a PCT, which is if you're interested in pursuing multiple patents internationally. And so that 12-month window, what it does is it allows you to go out there and explore your idea publicly. So shop the idea around, maybe talk to manufacturers, talk to potential customers, do a bunch of market research, and figure out if your idea is viable, if it's worth doing. If it is, then you don't have to spend that big money for the utility patent up front. You have that 12 months to kind of check it out, feel out the market, and see. So I know that this isn't quite clear. I want to try to give some examples. The best way that I can describe it is that it's like a placeholder in the calendar. So there's three really important things you need to understand about a utility patent. The first one is, in order to apply for a utility patent, your idea has to be novel. And what that means, I mean, there's a very specific definition, but what it means is it has to be new. It can't be already out there in the market. if you came up with an idea for a pencil, well, a pencil's already out there, so you can't patent it because it already exists. It's already public knowledge, and that public knowledge is referred to in the patent world as prior art. So if the idea has already been disclosed and it's out there in the world, it's not patentable, not eligible for a patent. So that, I guess that kind of brings me to the point number 2. It has to be non-disclosed, not publicly disclosed. So it has to be novel, new, and not disclosed. So that includes telling your parents or telling your buddies or posting a message on Facebook or whatever. Those are all ways. Those are all considered public disclosure. So you have to be really careful about how you approach your idea if you do have the intention of patenting in the future. The utility patent, I should say. And again, I just want to reiterate that the provisional patent application does not apply for a design patent. It's only for the utility patent. Now, USPTO, United States Patent and Trademark Office, allows any individual to file a provisional patent application themselves. So for $75 US at the time of this recording, you can go on the USPTO website and actually file your own provisional patent application. Now, I'm not telling you this is an easy process. It's very convoluted. It is not direct and straightforward. There are programs out there which can help you write it, whether it be books like I think the NOLO Law series has a book, although the book on filing a provisional patent is probably 1.5 inches thick. So I don't know how long that would take you to read, but quite a while. And then there are other services out there. So IP Watchdog is a website by a patent attorney called Gene Quinn. He seems to be a real expert in his field. He's put together a package for $99. You can go on his website and he walks you through the steps step by step. I think it's a 12 or 14 step process. Basically, he'll ask you questions. There'll be videos describing each section, what you should be including in that section, and then you just fill it out section by section. In the end, you generate the provisional patent application. You can attach your pictures, do all the descriptions in there, and then it spits out a couple of files in the end and gives you an instruction set on how to go through the USPTO website. So that's what I did my first time and my second time. I found great value in that, $99. So it's worth checking out if you are going to go down this road. You can always hire or pay a patent attorney to file a provisional patent application for you. Probably be in the neighborhood of a couple of grand. So some might be cheaper, some might be more expensive. But it is possible to do it yourself. And I want to point out, it is possible to do it yourself even if you're not from the United States. So I'm in Canada. This is Canmore, Alberta. And I'm still able to do that as a Canadian citizen. Now, I'm not able to file a trademark application at the USPTO myself as a non-American, but I am able to file a patent application. CIPO is the Canadian version of the Patent Office, and they respect, while they don't have the same provisional patent process, they do respect the American one. So if you get your filing in the US and you have that date as a placeholder, you can transfer that over and use that as the placeholder date for your Canadian filing as well. So let's talk a little bit more about what that process looks like and what protections it actually gives you. So a provisional patent application is just a placeholder. That's all it is. And let me describe quickly a scenario where it becomes very useful. I have an idea. I want to explore the idea. I don't necessarily want to shell out $20,000 for a utility patent until I know that my idea is good, until I know I've done the research and realized that it is novel, until I know it's never been disclosed publicly before, and until I realize there's a market. And can I build it or make it? This is an important piece. Can I build it or make it for less than what I can sell it for? I mean, there's no point in protecting an idea if you can't effectively manufacture it for less than what you can sell it for. If you can't generate a profit, there's probably not a point in doing it. So keep that in mind as you go through this process. But if I have this idea and I want to explore the idea, I want to find out, hey, are there people out there willing to buy it? Maybe some people have ideas for improvement on it before I even commit the money to having it manufactured or designed. And get the opinion, get some feedback. What would you pay for this type of item? So one of the ways you can do that is by filing this provisional patent application. Without the provisional patent application, if you try to reach out publicly and ask these questions and explore, with manufacturers and explore with market research and potential customers, you're going to need to operate under an NDA, which is a non-disclosure agreement in Canada or the US. In other parts of the world, they have other agreements. China's a triple N. And this becomes very important because without the non-disclosure agreement in place, it's considered public disclosure. Now, if you sent a private message to your buddy through a text, prior to ever filing an application, will they find out? Probably not. But let me put this out there to you. Let's say you find out it's a great idea. You pony up $20,000 and pay for a utility patent, and somewhere down the line there's a lawsuit involving you and a major company that's got unlimited resources. If they can somehow dig up any kind of proof at all that you have publicly disclosed previously, then that invalidates your patent. Doesn't matter if it was granted or not. They can say, hey, this was publicly disclosed prior to the date of filing. That patent's no good. Judge throws it out. Now you've wasted 20 grand. You're out all the legal fees. And now you've probably lost that revenue stream. So not worth doing. Get an NDA. Make your friends sign it. Make your parents sign it. If you think this idea is good enough that you've got, that you want to try to pursue it, formally and professionally. And let's face it, you're probably not going to drop 20 grand on filing a patent if you don't think it's a great idea and you haven't done at least some homework to back up the notion that it could potentially generate profit in the future. It should be mentioned that most patents filed, like the vast majority of patents filed, are never implemented or used, and many of them become non-profitable. So keep that in mind. It's not like filing a patent is the one-way ticket to success. It's a one-way ticket to burn 20 grand real quick. That's about all I can tell you. So what I want to say is, when you file the provisional patent application, you stake your claim for the date. So from this date forward, I have now secured a patent registration date. Just the date. You don't have any rights. You can't protect it. Legally, you can't send cease and desist because you don't have any protection. But it allows you to operate without an NDA from that date forward. And like I said, you have 12 months. If you don't take action within 12 months, technically, that information becomes public domain and you can never patent it again. You forfeit the eligibility to patent it. So keep that in mind. If you do go down this road and you file your PPA, there's a hard date, 12 months from the day of filing. So imagine this. I've got this idea. I'm not sure if it's viable yet or not. I can either drop 20 grand as a big gamble, not a good idea, or I can spend the 75 bucks, file a PPA myself, and then I can go out and explore and develop that idea. I can talk to stakeholders, I can talk to manufacturers, I can do market research and talk to the public. Now, is it possible that somebody comes along in the 12 months that has heard about your idea and build it before you? Yes, that is possible. Do you have any rights or ways to protect against that? No, you don't, not at this point. The only thing you can do is, if you go ahead and you file your full non-provisional utility patent within the 12 months and go through the full process, which could potentially take 3, 4, 5 years. I've even heard of up to 10, depending on how complicated it is. And then you're ultimately granted a patent. You then have the legal right to go back after that company and effectively sue them for all the potential lost earnings over that entire period. Because of this, it is very unlikely for an ethical company to ever want to steal your idea or impose it. When you have that provisional patent application in place, from the day you file it for 75 bucks, you can claim patent pending status, and you have that for 12 months. And no self-respecting company in their right mind is going to want to take a risk that you're going to go ahead in the future and actually file the utility patent, because they could potentially get sued for everything they've ever made with that idea from the very beginning. So it's a very good deterrent for legitimate companies. Let's just say that. There is still the challenge of dealing with overseas countries that don't necessarily respect the patents or our patent system. But you're going to face that whether you file the PPA or you don't file the PPA or you file the utility patent. You're still going to face that no matter what. So that's just something you have to get over. I struggled with that for a very long time, probably 2 years. I struggled with the fear of getting knocked off. And then once I saw other people starting to come up with a similar idea, I said, hey, I have nothing to fear anymore. My worst fear just came true. So just keep moving forward. Anyway, the PPA is really the way to go. 75 bucks. It saves you from getting everybody to sign NDAs from that point forward. And it really gives you a nice size window, 12 months, to hash out if your idea has legs or not, and determine if it's worth spending the full 20 grand on it. So, like I said, just to recap, you don't actually have any defendable patent rights other than being able to claim patent pending and reserving the date. And again, that just lets you go forward and do your research without having to get everybody to sign NDAs. And that also is important too, because when you talk to manufacturers, a lot of these guys refuse to sign NDAs. And that includes companies that are potential customers too. If you want to license that idea to a customer, they're Johnson & Johnson's not going to sign your NDA because they see thousands of ideas every day. Well, if they signed your NDA, that might actually encroach on somebody else's idea that they've already viewed or they're viewing in the future. And so they want nothing to do with it. So the onus is on you to have your idea protected. So that's kind of the basics of provisional patent versus utility patent versus design patent. And I think it's a really good idea to, if you believe you've got to get a good product or a good idea, good concept that's worth protecting, spend the 75 bucks, and maybe it's 75 bucks plus the $100 for the course and whatever else. But if you think this thing's worth more than a couple $100 as an idea, then definitely do that. Again, just let you speak openly about it and not fear, not have that same fear. Plus, being able to put patent pending on any kind of marketing or ideas or anything like that, packaging, it's a great way to announce to the world, hey, this is my idea. You stake your claim and you say, step off. Even though you don't have the right, if you do go ahead with filing that utility patent, you can come back and sue anybody in the future. So a lot of people just say, well, I want nothing to do with that. And that's money well spent, if you ask me. So patenting in general is potentially a really long process. The PPA filing is immediate. You do that yourself. There's a couple other details I just realized I have to point out with the provisional patent application. It is never reviewed, nor is it publicly posted. So that's a really important detail. What it means is when you send it off to the U.S. Patent and Trademark Office, nobody at that office actually opens up the file and looks at the content of it. This is really important. What it effectively means is you've registered the information on file with them, but it's not filed anywhere. It's kind of just in this limbo, in this ether somewhere. And it's waiting to be called upon when you file a real patent, a full non-provisional utility patent. If you never file that patent, those documents never get called upon, and ultimately they get destroyed. They are not, or maybe not destroyed, but just keep in mind they're not made public. So while the letter of the law says that if you file a provisional patent application for a particular idea and 12 months elapses and you don't take action on it, it's never eligible to be patented again in the future by anyone. The reality is nobody actually knows what you filed. So in theory, you could file the same provisional patent application every single day of the year, and it could be the exact same thing. I mean, you'd have to pay 75 bucks a day to do that, but if you wanted to, it is possible. And then at the end of the 12 months, like I said, it's never disclosed. So it's not like all these people are submitting ideas for provisional patent applications, and then if the patents aren't filed, then they just get released publicly. No, the only way that somebody ever finds out about your idea is if you disclose publicly. And maybe once you file that PPA, you do put it out there. You talk to the manufacturers and you ask people for market feedback. So you are putting it out there, but technically nobody reviews it at the Patent and Trademark Office. So let me give you a really specific example of why that's important. So another critical detail, when you file a provisional patent application, whatever is contained within the provisional patent application itself can be called upon and used within the full utility patent. If it is not previously mentioned within the provisional patent application, it cannot be used or claimed in the full utility patent. What that means is if I come up with a widget and then I file a provisional patent application, and then 6 months later, I think, oh wow, I should have included this feature. I just thought of a new feature that makes it twice as desirable. If I want to include that second feature, and it's not originally in the provisional patent application, then technically I can't use that provisional patent application date to file a utility patent that has both the features, or that has the second better feature in it. But what you can do is you can file a second provisional patent application. Unfortunately, you're going to lose your original date, so there's no way to extend it or amend it or change it. But at least at that point, you can still get that PPA filing and reserve that date. Now, that would also give you another 12 months, but keep in mind, if anybody knocks you off from before that date, then you could find yourself filing a utility patent for no reason. So make sure if you do file a provisional patent application that you include as much detail as you can, even if that detail is not super specific. If it's fairly broad, I mean, if it's too broad, you won't be allowed to use it anyway. But if it's too narrowly focused, as you come up with new ideas in the future, you won't be able to include those. And that's a very dangerous thing. So I would say try to get the right balance where you're describing your product as it exists, but you're also describing potential future versions of your product or add-ons or future design elements that you're thinking about, and you can be kind of broad on that, but just not too broad. You can't say, oh, well, I invented a vehicle. Well, no, it's got to have some specifics to it. But if you think about some of those things you want to do in the future, maybe the first iteration of your product has to be a very simple one because of time, budget, complexity, and that's okay. But also be thinking about how you could improve it in the future. What are the other upgrades or add-ons or features or different ways you could use this outside of the conventional methods that might come into play later down the road, and try to capture as much information as you can. So if you're understanding this correctly, you could, because it's not reviewed, you could file a PPA that's blank, but it doesn't do you any good, because when you go to file your utility patent, you're not going to be able to use any of the information contained within. So the onus is on you to be as detailed as possible, and it is in your best interest to be as detailed as possible. And I would say that it's important to take more time doing that. Now, really important, a provisional patent application doesn't actually make any claims. Claims are the legal definitions that are protected under a patent. So you're not actually making specific claims. What you're more or less doing is describing in layman's terms or in simple plain English the concept of what you're trying to protect. So a full utility patent it's going to be in legalese, and it has to have definable claims that you're trying to protect. This is really where you're going to want to get a professional involved. This is why it costs big money. But in the provisional, you don't need legalese. You're not making any specific claims. It's not reviewed, and you can write it in plain English. And that, I mean, it's not ideal, but in theory, you could actually have drawings on a napkin, scan them in, and include it in your application. It brings me to another point of the drawings. Do you need professional patent drawings for a provisional patent application? No, you do not. The more drawings you include, the easier it is to visualize, the more descriptive it can be, because there's a lot of things that can be described in an image or a picture that are very challenging to describe in words. So I would encourage you to include as many pictures as you can. And I should specify, excuse me, I should specify uh, that the images that you're going to include are more or less diagrams, so not pictures. You're not going to take pictures with your cell phone of your prototypes. You're going to want to have them sketched out, and they could be hand sketched. You could have a graphic artist do it. You could go on Fiverr or Upwork and have it done fairly inexpensively. If you're using CAD design software, a lot of the softwares have the ability to export, 2D engineering drawings of whatever thing you've got modeled. So there are a number of ways to do it, but diagrams. When I say pictures, I mean diagrams. You want to have as many diagrams as you can. Um, Even if you've only got one embodiment of a thing, like, one shape and size, and you're trying to describe a whole bunch of, like, a range of shapes and sizes to work with different types of things, that's okay, as long as you're showing some examples. And again, if it ever came down to it, down the road, maybe you've got a multi-million-dollar business successfully running, and somebody challenges the claims in your patent, you can actually refer back to that provisional patent application, pull up those original drawings, pull up those original descriptions. So even though it's not super important right now, it may become important later in the future. So spend some time, take some time. If it costs you a couple $100 to get drawings done or to have somebody review it, there are patent lawyers out there for a few $100s. They'll look over the provisional patent you've written and give their spin on it. So that might be worth doing too. And let's face it, I mean, protecting your idea is expensive, but it's probably a drop in the bucket compared to starting an entire business, manufacturing product and supply chain and employees and everything else. So if you're concerned about spending $100 on your patent drawings or on the patent course or the 75 to file the PPA, then I think you really need to go back to the drawing board and revisit whether this idea is worth protecting or not. Because if you want to start a real legitimate business, it's going to take cash and capital. And that's maybe a whole nother video about different ways you can try to fund your startup or your business. But in terms of the patent, this is the only protection you have. So treat it accordingly, budget for it. And maybe that's a good segue to talk about cost. So again, I'm not a patent attorney. I'm in Canada. My rates are going to vary from the next guy in the next company in the next country and yada yada. But let's talk about this real quick. USPTO, $75 for a PPA filing that you do yourself. You could spend $1, $2, $3, $4, $5,000 having an attorney draw up a provisional patent application. It's going to be a lot more professional than your home jobber self-written one. And consider this: the more money you spend with a real lawyer on the provisional, probably the more money you're going to save when it comes time to file the full utility patent. The reason is because if a lawyer has already drawn up a lot of the legalese and described your concept or your idea in the provisional in a way that they can just kind of not cut and paste, but in a way that they can take that same information and apply it over to the utility, then you've kind of prepaid ahead of time for some of the work that's got to be done in the utility. If you do it all yourself, the lawyer's going to be starting from scratch. And in the end of the day, it's probably half a dozen of one and 6 of the other. So I would say there's not a right way to do it. If you're really strapped for cash, spend the 75 and do it yourself. But if you have the budget, maybe get a professional lawyer to draw up even your provisional. It will save you a little bit of money in the future when you file the utility, if you file the utility. So let's talk about the costs involved with a utility patent. You have probably heard of all kinds of different crazy prices, just like I have. And honestly, I think there's probably a lot of truth to all of it. There are probably patent attorneys out there who charge very little for the service because they don't value their time as much. And there are probably big international firms that charge hundreds of thousands of dollars for a similar service. What I can tell you is if you're on a budget and you're shopping around, a utility patent is probably in the neighborhood of $15,000 to $25,000, and let's just call it 20 grand to be using round numbers. The reason, though, is not, you don't have to stroke a check for 20 grand on the first day and hand it over. The reason is because there's a process involved. So there's the original provisional patent application if you choose to go that way. Like I said, another option is filing it yourself. But if you hire a lawyer to do that, that might be $2,000, $3,000, $4,000, $5,000. When you file the actual utility patent, that might only cost you $5,000 to $8,000 to have them draw it up for you, depending on how long it is, how many claims you have to make, and what you're trying to describe. After that, then you're going to have the patent is going to be filed at the USPTO, and then it's probably going to be quite a long time before anything happens. But basically, and I should specify, you can also claim patent pending during that process as well. Once the patent is in that process, it's I believe it's called being prosecuted. So the patent is prosecuted, and what that means is a patent examiner is going to go and read through all of the information that you're presenting and all of your arguments. They are going to go out and do their own research and see if what you're trying to claim is infringing on any pre-existing patents, and again, that's called prior art. So a patent examiner will see what you're trying to protect and see if there's prior art that already exists. If there is, then you can't claim it because it's already there. And then they're probably going to come back with something called office actions. And that's basically where the examiner comes back to you or your attorney and gives you the opportunity to argue your case. They're pretty much going to always deny your claims. So don't get discouraged if that happens. That's part of the process. They come back. They say, hey, you've made this claim that you want to protect. We don't necessarily think that you have the right to do that because these other examples exist over here. It's your turn to present your case. Argue why you think your particular idea is different, why it's protectable, and so on. Your attorney is going to charge you additional fees for these office action responses. And there is no telling how many there might be or what will be requested, how long it will take to answer those office actions, and therefore there's no way to accurately calculate what the total cost of the patent is going to be. You know, it might only cost you $6,000 or $8,000 to do the initial filing, but if you go through a whole series of lengthy office actions, I mean, the bill could rack up $5,000, $6,000, $7,000 potentially. And then also you've got a bunch of fees directly from the U.S. Patent and Trademark Office, which are called maintenance fees. And essentially that's to pay to keep your patent alive. Just like you have to register your vehicle every year and pay your property tax. If you want to stake your claim for 20 years, 20 years is the timeline for a utility patent. If you want to stake your claim on a patent, you've got to continue to pay your annual dues to the USPTO. And over the life of a utility patent, that can end up being thousands and thousands of dollars. So that's kind of where, you know, those larger numbers of $20,000, $25,000 come from. And again, it can get much higher depending on how complex your idea is and the lawyers involved, and if you try to do international patents through a PCT, etc. So those are some ideas, some benchmarks for costs. And then the other type, which is the design patent, that's a little bit cheaper, a little bit easier to get. Here's my exact item. These are the dimensions. This is the material it's made with. This is potentially how it's made. That might be part of your patent, maybe not. And that's going to cost in the neighborhood of $2,500 to maybe $5,000 or $6,000 all in. So again, don't hold my word to it. It depends on the country you're in and the lawyer you're dealing with and how complex your idea is and what other things exist that you have to try to overcome in terms of objection from the prosecution. Anyway, that's hopefully an overview of what the different types of patents are, what they cost. The only other thing I guess I didn't cover totally is the time frame. I did hint on it, but utility patent could potentially be, 3 years, could be 4 or 5, and I've heard up to 10 for really complicated ideas. And it also depends too on if you are filing internationally for that PCT. And I don't know a ton about that process, but I understand that a PCT is when instead of taking your provisional patent application and saying, okay, I'm filing my US non-provisional utility patent, you say, hey, I'm planning on filing a whole bunch of the same utility patents in multiple different countries. That maybe I'll touch on that briefly. When you file a utility patent, the utility patent is really only good for the country that you file it in. So if you want your utility patent to be good for multiple different countries, you're going to have to file in all of those different countries separately. Now there is an international body, and there's a standard. The name escapes me right now. Forgive me. You can Google it. But there is a patent treaty that exists that allows multiple different countries to respect patents that are filed, and it doesn't give you the same rights as filing within the countries would, but it does certainly exclude some people and companies from within countries, certain countries, from infringing on you for fear of retaliation or legal ramifications. So obviously that's probably not going to help you in some of the Asian countries, but it might help you in say Europe or Canada or etc. Sorry for the noise there in the background. So yeah, I would say you got to really do some digging and find out if your idea is worth all of this trouble. If you're trying to reinvent the wheel, don't waste your time. Just go out there and make it, because it already exists. It's not eligible for a patent anyway. If it's just a little tweak, I mean, is it eligible? Maybe. Is it worth patenting? Maybe not. It also depends on the on the size of your market. If you've got an idea that's a multi-million-dollar idea, then it's probably worth spending a little bit of money to protect that idea. But just because you think it's a multi-million-dollar idea doesn't mean it's a multi-million-dollar idea. And don't rely on the opinion of your friends and family, because they want you to succeed, they want you to do well, they want to encourage you, and they will tell you whatever they think you want to hear to get you to continue down the path. So make sure that you get some independent outside feedback. Again, once you file that provisional patent application, that opens up the doors and allows you to talk to people openly about your idea. When I filed mine, I kind of kept my cards still close to my chest. I recorded who I told and what date I told them, just because you don't necessarily want to go announce it to the world on Facebook. That's just asking for trouble. So use some judgment here and some common sense. But if you have a private Facebook group locked down under access only people that you approve, and you invite some people to that group to get some market data or feedback, you could call that a pre-launch group. That's a good way to get some feedback, share some options, and see what the general public wants to say about it, but without putting it out there to hundreds or thousands or millions of people. So hopefully that's given you some insight. I know it's not super detailed, but it should give you the basics in order to make an educated decision on the path you want to follow. And I hope it helps. Please like and follow us, and share it with your friends. Anybody who's in the inventor community, they need all the help they can get. So this is free advice. And stay tuned. We'll try to come up with more information as we discover it. We'll go through this journey together. Thanks a lot.